Hello, Ben Bierce with Brave Investigations. In this video, we'll talk about 10 critical cell phone questions for interrogatories in civil litigation. In the intricate landscape of civil litigation, cell phone evidence stands as a pivotal element. However, most cell phone evidence is fragile. Most cell phone companies only keep their records for a certain period of time. And the evidence on the cell phone itself is fragile. It can be deleted intentionally by the user or unintentionally through a process of the operating system of the phone. We need to identify potential evidence valuable to our cases and take steps to preserve that evidence as early as possible. How do we find out if there were phones present at the time of the incident? And how do we identify the phones and their phone numbers? We could review the crash report for phone numbers, or we could interview witnesses, law enforcement, or emergency personnel on scene at the time of the incident. Probably the most efficient way to identify phones and phone numbers that were present at the scene at the time of the incident is through interrogatories. This video will cover interrogatory questions valuable for identifying potential cell phone evidence. Question number 1. Was the plaintiff or defendant using a mobile device at the time of the incident, to include, but not limited to, engaged in a voice phone call, sending or reading a text message, streaming media, using a navigation program, browsing social media, reading or sending email, taking or viewing photos, video, or audio, browsing websites, listening to music, audiobooks, or podcasts, or viewing documents? Some of the activities mentioned before require active use by the user, but others are passive. In a motor vehicle crash case, the active activities suggest distraction by the driver. The passive activities may give us some insight when compared to the data log of the phone records. If the subject denies using his or her phone at the time of the crash, and also denies using apps such as media streaming or navigation, and we find data usage in the phone records, we may be able to show that the subject is not telling the truth. Question number 2. List all mobile devices present during the incident, including, but not limited to, cell phones, tablets, music players, game devices, drones, GPS devices, and Bluetooth or connected devices, including, but not limited to, hands-free devices, smartwatches, and the vehicle infotainment system. This includes mobile devices belonging to people other than the plaintiff or defendant. We would like to know all the devices present at the time of the incident. More than likely, there was at least one device present at the time of the incident, but some people have more than one cell phone. From my time as a police detective, I know that drug dealers usually have at least 2 cell phones, one to contact their family and the other for business. This is common among law-abiding people as well. Some people may have personal cell phones and also have separate cell phones provided by their employers. Also, other people present at the time of the incident may have cell phones that contain valuable evidence. We want to know about all the devices present at the time of the incident, such as cell phones belonging to passengers in a car that was involved in a crash. In addition to cell phones, there may have been other devices present at the time of the incident. This may include tablets, game devices, music players, and drones. For example, an over-the-road truck driver would likely have his iPad in the cab of the truck for use when he is not driving. However, it is possible that the truck driver was using his iPad at the time of the crash. Another example would be a drone used to take video at the time of the incident. The drone operator may or may not be related to the subject of the incident, but a drone taking a video at the time of the incident might be valuable. A common defense in motor vehicle crashes is that the driver was using a Bluetooth hands-free device at the time of the crash. Obtaining these Bluetooth devices will help confirm their usage at the time of the crash. Smartwatches are also valuable. A driver may not have been using his or her cell phone at the time of the crash, but he or she may have been using his or her smartwatch. Some smartwatches can connect directly to the mobile data network and work independently of the connected phone? Question number 3. Who are the owners of all the devices not owned by the plaintiff or defendant? And provide contact information for all the other owners. Some of the devices present at the time of the incident may belong to other people. The subject of the investigation would likely not have possession of these devices and also would not be able to provide consent for their examination. But the subject can provide us with information that will help us contact the owners of these other devices. Question number 4. What are the phone numbers and carriers for all of the cell phones involved in the incident, along with all the International Mobile Equipment Identifiers, IMEI, Mobile Equipment Identifiers, MEID, or International Mobile Subscriber Identifiers, IMSI, and carriers for all devices other than cell phones that have independent access to the cellular network. Many devices can have accounts with cell phone carriers that allow these devices to access the mobile data network. The most obvious example is a tablet. Cell phone carriers offer plans for tablets like iPads to connect to the mobile data network when they are not in range of Wi-Fi. Other devices, like smartwatches, can have plans as well. We can send subpoenas to the cell phone company for logs of the data usage of these devices. We can replace the phone number with the IMEI, MEID, or IMSI in the subpoena. The records we receive will be similar to the call detail records that we get for a cell phone, but they just won't have the call or text logs. With some carriers, we may be able to obtain the cell site locations as well. Question number 5. Is the plaintiff or defendant still in possession of the devices? If not, which devices does the plaintiff or defendant still possess, and when did the plaintiff or defendant dispossess each of the devices that he or she now no longer has? Where are these devices now? We would like to know if the subject still has the devices. If the subject no longer has some of the devices, we would like to know how he or she got rid of those devices. If the subject recently traded in the phone for a new phone at the store, we may be able to go to the phone store and get the old one. This should save us time in knowing which devices aren't worth going after. Question number 6. Are the devices still in use by the plaintiff or defendant? If they aren't, when did the plaintiff or defendant stop using the devices and why? Is someone else using the devices? If so, provide contact information for that person. If the subject is still using the same device months or years after the incident, recovering data from the day of the incident becomes less and less likely with each passing month. Of course, it depends on the type of device, the volume of usage, and whether or not the evidence has been deleted from the device. The best scenario would be for the police to collect the phone. The next best scenario would be for the user to stop using the device shortly after the incident and put it in a drawer and save it. If the subject is not using the device anymore, we would like to know why. Was the phone broken? It would actually be in our favor if the phone was broken during the incident or shortly afterwards. There wouldn't be much time to eradicate evidence from the device, and we could send the device to a forensic laboratory for repair and data recovery. If the subject got a new phone and gave the old phone to a child, and the child put his or her profile on the phone, then recovering the data from the subject would be nearly impossible. Question number 7. What is the condition of the devices? If the phone is in working order, then the expert would likely be able to extract the data. If the phone isn't in working condition, then it can either be repaired or sent to a lab as mentioned in the previous section. Question number 8. Has the device been restored to factory settings since the date of the incident? If the phone has been factory reset since the incident, the likelihood of getting any information from the phone is almost non-existent unless the phone was restored with the same account. All iPhones and higher-end Androids are encrypted by default. Your expert can bypass the encryption using the passcode. Though the data may technically still be there after a factory reset, the data cannot be decrypted. If the phone was restored to the same account as at the time of the incident, there would be value in extracting data from it. It just wouldn't have as much data around the time of the incident as if it had not been restored. Question number 9. If the plaintiff or defendant has a new phone, was the data from the old phone transferred to the new phone? If the new phone was restored from a backup from the old phone, then the likelihood of recovering evidence goes up. I used to have an iPhone 12, but then I upgraded to an iPhone 15. I backed up my iPhone 12 to the iCloud, and then when I got the iPhone 15, I restored it from a backup from the iPhone 12. Most of the information from my old iPhone was then put on my new iPhone, including text messages that had not been deleted. Android phones can be restored from backups or the cloud as well. Question number 10. Has the plaintiff or defendant sent any communication, including text messages, email messages, or social media posts concerning the incident from the device? Sometimes the subject will send the digital equivalent of an excited utterance through his or her phone. The subject may send a text message to a friend or loved one that has something in it that suggests that the subject was at fault in the crash. Or the subject may post something on social media expressing regret for his or her actions. Bonus question: did anyone else have access to the device around the time of the incident? A common defense is that someone else was using the phone. If the subject was alone in the car, obviously this defense wouldn't work. But if there was someone else in the car at the time of the incident, we would like to lock the subject in to whether or not the other person had access to the phone. If someone else did have access to the phone, it's important to ask how that person had access to the phone. Did the other person have the password, or did the subject unlock the phone for them? These questions will help us to identify devices and phone numbers so that we can send preservation letters. I recommend sending these questions as early as possible. We need to move fast to preserve this evidence. The more time that passes between the incident and the preservation request, the more likely the evidence will be irrevocably lost. This list of suggested questions is not all-inclusive. These are things that I, as the examiner, would like to know. I am not an attorney, and some of these questions may not be appropriate in some cases or in some jurisdictions. Every case is unique, and there will likely be some circumstances that these questions just don't cover. If you have any questions, please don't hesitate to reach out to me by phone or email. You can find my contact information at braveinvestigations.com. Thank you for watching. I hope you found this valuable and have a great day.